Without further ado, I will now hand over to Nadine.
Thank you very much for that, Chris, and thank you so much to everyone who's tuned in today. It's a really terrible time. It's been difficult, I'll admit, for me to put my mind to thinking about my book, and it has somewhat helped me to be asked to do this, because it is good to have thought about the book and tried particularly to think about it in the context of what's happening right now. That's helped me to make sense a bit of what's happening right now. And so what I've tried to do is to, in my introduction, what I will do is talk a little bit about what's happening with the current health crisis and how it relates to some of the themes I explore in the book. And then I will read a couple of extracts from the book. One will introduce you to the main themes of the book, the main argument of the book, and the other I have chosen, I think, because it really does help us to reflect on what's happening right now with the current health crisis. So I'll be reading sections of the book which speak to the colonial logics at play in the British government's management of the current health crisis. As we know, Boris Johnson allowed the virus to move through the population. That's a quote from him. He admitted to being tempted to do this, and he allowed it to happen. Britain is heading towards, if it isn't there already, having the highest death toll in Europe. Johnson's herd immunity approach necessitates the death of large numbers of people who fall ill with the virus. At the time he decided to follow this policy, it was widely understood that the virus was particularly dangerous for older people and those with underlying health conditions. Johnson treated vulnerable people as surplus population, acceptable sacrifices, so that Britain could remain open for business. This dangerous position was exacerbated by a combination of arrogance and racism on the part of officials who considered the virus to be something happening over there to people who were not white, not European, not British, and who didn't matter. The assumption was that it would not reach Britain, and that if it did, Britain would be better placed to deal with it. This murderous combination of exceptionalism, complacency, and eugenics is not new to British rule. Such features comprised an important part of colonial rule in the era of the British Empire. Colonial subjects were left to die as famines took hold, as illness spread through populations, as people's lands and livelihoods were taken from them in the course of colonial conquest. Colonial authorities deployed a let-die logic laced with ideas of white superiority, seeing illness and famine as nature's way of dealing with populations deemed surplus. The victims of today's health crisis are disproportionately Britain's racialised population. Indeed, racialised people everywhere are dying of the virus in disproportionate numbers. In Britain, we can see the racialised effects of how the response to the virus is being governed, together with the implications of pre-existing and intersecting structures of race and class. 70% of frontline health and social care workers who have died of the virus are from racialised communities. Health workers are being asked to sacrifice their lives and the welfare of their families in a context in which they were so recently constructed as unskilled and unwanted. Meanwhile, research found that 35% of almost 2,000 coronavirus patients in intensive care are non-white, even though they make up 13% of Britain's population. Again, such disproportional susceptibility to premature death of racialised people is commonplace. 50% of people of African descent live in poverty, and overall 2/5 of ethnic minorities live in a household earning below average income. 30% of Britain's Bangladeshi population live in overcrowded housing conditions, compared with 2% of the white British population. 15% of Britain's black population and 16% of its Pakistani population live in overcrowded housing conditions. In London, more than a quarter of transport workers driving tube trains and buses which have remained in operation are racialised. If we add to this doctors' prioritisation of treatment of people without underlying health conditions, we can see how racialised people come to be disproportionately represented in the numbers of deaths. Of course, disproportionate vulnerability to premature death is not a new condition for racialised populations, whether they live in or outside the colonial metropole. We need only think of deaths in custody, the Windrush scandal, and the Grenfell Tower fire to see this borne out. My book addresses the way in which British immigration law specifically has consistently made racialised people vulnerable. So I'm now going to read a section of the book which, as I mentioned, outlines key arguments, followed by one which addresses a particular case, which will allow us to reflect on how the British legal system is infused with the very colonial let die logic, which we see at play in the current health crisis, and how this has always impacted racialised people disproportionately. In answer to the question about why annual net immigration was above the Conservative Party's tens of thousands target in 2012, the Home Secretary Theresa May stated that her aim was to create here in Britain a really hostile environment for illegal immigrants. What we don't want, she said, is a situation where people think that they can come here and overstay because they're able to access everything they need. The notion of the unjustly enriched migrant has long been at the heart of British immigration policy. It is spurred on by a widespread and concerted refusal to understand contemporary British politics in the context of Britain's colonial history. The failure to connect the presence of many racialised people in Britain to the destruction and dispossession of British colonialism is as profound as it is pervasive. Absent from mainstream political discourse is any acknowledgement that the making of Britain's modern state infrastructure, including its welfare state, was dependent on resources acquired through colonial conquest. At the same time, people with personal, ancestral, or geographical histories of colonisation cannot escape their condition of coloniality. There is a direct causal link between colonialism and ongoing wealth disparity and inequality in income and land distribution in former colonies. Poverty, dispossession, and exponentially high mortality rates are lasting legacies for population in Britain's former colonies. Meanwhile, for the racialised poor living in the heart of the imperial metropole, insecurity and a disproportionate vulnerability to premature death is a long-standing and everyday experience. The 2017 Grenfell Tower fire and the 2018 Windrush scandal are illustrative of Britain as a domestic space of colonialism, in which the racialised poor find themselves segregated and controlled, vulnerable to deprivation, exile, and death. The abstraction of day-to-day life in Britain from its colonial history means that immigration law and policy, whether in the form of the hostile environment, visa requirements, or other external border controls, are not seen as ongoing expressions of empire. Yet this is what they are, part of an attempt to control access to the spoils of empire which are located in Britain. British colonialism is thus an ongoing project sustained via the structure of law. It is Britain that has been unjustly enriched through centuries of colonialism, and immigration law is the tool that ensures that dispossessed peoples have no claim over what was stolen from them. Britain is a place produced by colonialism and slavery, which were key to its industrialisation and the growth of its capitalist economy. In 1833, Britain abolished slavery and raised the modern-day equivalent of £17 billion through taxation and loans to pay compensation to British slave owners for the loss of their property. The compensation scheme was the largest state-sponsored payout in British history until it was superseded by the bank bailouts of 2008. The funds paid out built and infused Britain's commercial, cultural, imperial, and political institutions. The scheme is just one example of a direct financial link between slavery and imperialism and the place that is Britain today. The reinvestment of profits from slavery and post-abolition compensation are demonstrative of placemaking in a most material sense. On the eve of the abolition of slavery in Britain, over a third of investors in the West India and London docks were active in the slave trade, whether by owning slaves or in shipping, trading, financing, and insuring slave produce. The redeployment of profits from slavery and compensation in commercial and industrial activities and physical infrastructure occurred over the 19th century and into the 20th and even 21st. Wealth derived from British slave ownership has by no means been evenly distributed in Britain. It has helped to enrich and sustain elite institutions, individuals, and families, and has sown inequality deep into the fabric of British society, helping to make it the most unequal place in Europe. Yet Britain's healthcare system, welfare state, transport infrastructure, cultural and educational institutions battered and unequally accessible as they are in the wake of privatization and austerity policies, are colonially derived, along with the private wealth amassed over the course of the British Empire and retained after its defeat via systems of inheritance. Britain is a young nation state, but an old imperial power. The task of bordering Britain is an ongoing and centuries-old process. Britain's borders, articulated and policed via immigration laws, maintain the global racial order established by colonialism, whereby colonized peoples are dispossessed of land and resources. They also maintain Britain as a racially and colonially configured space in which the racialized poor are subject to the operation of internal borders and are disproportionately vulnerable to street and state racial terror. Britain is thus not only bordered, but also racially and colonially ordered through the operation of immigration control. The 1960s, 70s, and 80s are particularly important decades in the story of British immigration law and the making of modern Britain. Over the course of these decades, immigration law played a crucial role in Britain's transition from an empire to a sovereign bordered nation state. As colonial populations drove the British from their territories, winning their independence, British politicians were forced to come to terms with the defeat of the British Empire. The myth of imperial unity and equality was fast abandoned by British lawmakers as they moved to introduce controls targeted at racialised subjects and Commonwealth citizens. This legislation culminated in the 1981 British Nationality Act, which raised for the first time the spectre of a post-imperial, territorially defined and circumscribed Britain. It severed a notionally white, geographically distinct Britain from the remainder of its colonies and Commonwealth. The move was both materially and symbolically significant. A territorially distinct Britain and a concept of citizenship that made Britishness commensurate with whiteness made it clear that Britain, the landmass and everything within it, belongs to Britons, conceived intrinsically as white. According to the 1971 Immigration Act, only patriots, those born in Britain or with a parent born in Britain, had a right of abode and therefore a right of entry and stay in Britain. In 1971, a person born in Britain was most likely, 98% likely, to be white. The 1981 Act continued this process of racial exclusion by constructing British citizenship on the foundation of the 1971 Act's concept of patriality, tying citizenship to the right of entry and abode. The effect of the 1981 Act, along with changes to immigration legislation in the course of the 60s and 70s, was to put the wealth of Britain, gained via colonial conquest, out of reach for the vast majority of people racialized through colonial processes, most of whom had geographical or ancestral histories of British colonialism. The 1981 Act did not signify an end to British colonialism, but was itself a significant colonial maneuver. It was an act of appropriation, a final seizure of the wealth and infrastructure secured through centuries of colonial conquest. British immigration law, in serving to legitimise ongoing theft of colonial wealth, must therefore be understood as being on a continuum of colonialism. It is through immigration law's policing of access to colonial spoils that the racial project of capitalist accumulation is maintained, a project which I argue is legitimised through judicial rulings in immigration and asylum cases. Immigration law is also the prop used to teach white British citizens that what Britain plundered from its colonies is theirs and theirs alone. Racial placemaking projects like that of bordering Britain, and before it the expansion of the British Empire, rely on the institution of racial terror. Once the enactment of racial terror is initiated by the state, it is a task assumed by citizens. They are taught, in part through immigration law, that the parameters of the imperial and national project of ensuring white entitlement to wealth gained in the course of colonial conquest are theirs to enforce. Immigration law is not, therefore, the seemingly harsh but fair mode through which the deserving are separated from the undeserving. Instead, it is a crucial mechanism for ensuring that colonial wealth remains out of the hands of those from whom it was stolen. A case which powerfully demonstrates the way in which access to colonial spoils is withheld from people with geographical or ancestral links of colonization is that of N. N's life depended on access to medical treatment in Britain, and she sought to challenge a removal decision to Uganda on the basis of Article 3 of the European Convention on Human Rights, which protects people from being sent to places where they would risk torture or inhuman or degrading treatment or punishment. In ruling that Article 3 does not oblige states to grant migrants access to their healthcare systems, the Supreme Court effectively handed N a death sentence. The court adopted the rationale that a decision in favour of N would have risked more people seeking to travel to Britain to access vital healthcare to which they are not entitled. The judges employed a depoliticising logic, arguing that wealth inequalities between nations and illnesses are natural or chance occurrences. The effect is to obscure colonial powers' role in producing global wealth and health disparities and their reparative obligations towards colonised populations. So I'm now going to skip forward and talk a bit more about the case of N. And before I do that, I'm just going to give a bit of context to the case. On introducing the 1996 Asylum and Immigration Act, Michael Howard had explicitly linked asylum with welfare, arguing that Britain is far too attractive a destination for bogus asylum seekers and other illegal immigrants. The reason is simple, he said. It is far easier to obtain access to jobs and benefits here than almost anywhere else. Howard thus peddled the notion that people travel to Britain to access resources to which they are not entitled. This history-effacing narrative has long provided the justification for the introduction of measures which make it more difficult for people to access vital support services after arriving in Britain. In a precursor to the hostile environment policy introduced by Theresa May in 2014, in 1995, Howard called for the NHS to find better ways of controlling access to free medical treatment and to improve procedures to enable providers of benefits and services to identify ineligible persons from abroad. Limitations imposed on asylum seekers' access to support and welfare services operate on the assumption that the majority of asylum seekers are bogus and undeserving, while the minority granted convention status are deserving. The 1996 Act limited access to welfare for persons seeking protection. There were media reports in the 1990s of hospitals refusing treatment to Kurdish people without documentation proving their protection status. In 1996, the Home Office issued guidelines targeted at welfare departments concerned with housing, student bursaries, and council tax benefits, inviting local authorities to use the facilities offered by the Home Office in identifying claimants who may be ineligible for a benefit or service by virtue of their immigration status, and to encourage local authorities to pass information to the Home Office about suspected immigration offenders. The cases that perhaps best demonstrate the way in which access to colonial spoils is withheld from people with geographical or ancestral histories of colonialism are those that involve people whose lives depend on being granted permission to remain in Britain so that they can continue accessing vital healthcare. Such cases are based on Article 3 of the European Convention on Human Rights, which provides that no one shall be subjected to torture or inhuman or degrading treatment or punishment. Despite the absolute terms of this provision, it has been held to apply to medical treatment cases only in very exceptional circumstances. The result is that the courts regularly preside over sending of people back to certain death. In the case of N and Secretary of State for the Home Department, the Supreme Court set out the test as being whether the applicant's illness has reached such a critical stage, i.e. he is dying, that it would be inhuman treatment to deprive him of the care which he is currently receiving and send him home to an early death, unless there is care available there to enable him to meet that fate with dignity. N, from Uganda, a former British colony, was receiving treatment for HIV/AIDS when she faced removal from Britain. She was not dying in the sense that the medical treatment she was receiving in Britain was effective. However, as she argued, if she were to be returned to Uganda, her rights under Article 3 would be breached because she would not have access to the medication she required in order to stay alive, and she would die a very painful death. The Supreme Court judges who considered her case were well aware of this fact. Lord Nichols stated that N's doctors say that if she continues to have access to the drugs and medical facilities available in the United Kingdom, she should remain well for decades. But without these drugs and facilities, her prognosis is appalling. She will suffer ill health, discomfort, pain, and death within a year or two. According to Lord Hope, N's prospects for surviving for more than a year or two if she were returned to Uganda were bleak. He said it is highly likely that the advanced medical care which has stabilized her condition by suppressing the HIV virus and would sustain her in good health were she to remain in this country for decades will no longer be available to her. If it is not, her condition is likely to reactivate and to deteriorate rapidly. There is no doubt that if that happens, she will face an early death after a period of acute physical and mental suffering. Nevertheless, the Supreme Court deemed that the Article 3 threshold had not been reached in N's case. While the judges considered the pain, suffering, and death that N would experience should she be removed as being of the utmost humanitarian concern, they nevertheless found that the Convention does not oblige states to grant the right to remain to people in order to avoid such outcomes. Precisely because N was receiving effective treatment and was not on her deathbed, her case fell outside the scope of Article 3. Lord Nichols described N's removal as tantamount to having a life support machine switched off, an entirely inappropriate comparison since life support machines are switched off in cases where there is no hope of recovery, whereas N could have lived a long and healthy life had she been permitted to stay in Britain and access the medication she needed. Lord Hope stated that the question must be always whether the enlargement in the interpretation of the Convention on Human Rights is one which the contracting parties would have accepted and agreed to be bound by. By confining the question before them to one of the extent of the obligations under Article 3, the court could omit consideration of what a humanitarian approach required, as well as what justice demanded. A just approach, for example, might see states' obligations toward the populations of their former colonies as being reparative. It is clear that the Supreme Court's decision was driven by specific policy goals rather than the wording of Article 3 of the Convention. There is no doubt that the conditions N faced on removal fell within the ordinary meaning of the terms inhuman and degrading. For the court, the policy question at issue was one of access to resources understood as belonging to those legally entitled to be in Britain and at the risk of depletion on account of immigration. Article 3 could not be allowed to function as a route to immigration status. Lord Hope thus considered that a finding in N's favour would risk drawing into the United Kingdom large numbers of people already suffering from HIV in the hope that they too could remain here indefinitely so that they could take the benefit of the medical resources that are available in this country. The court understood the dilemma it faced as being a choice between allowing the patient to remain in the host state to enjoy decades of healthy life at the expense of that state, an expense both in terms of the cost of continuing treatment, the medication itself being said by the government to cost some £7,000 per year, and any associated welfare benefits, and also in terms of immigration control and the likely impact of such a ruling upon other AIDS sufferers aspiring to these benefits. And on the other hand, deporting the patient to a life of rapidly declining health, leading to a comparatively early death. By contrast, the dissenting judges made short shrift of the floodgates argument, stating that when one compares the total number of requests received and those refused and accepted as against the number of HIV cases, the so-called floodgate argument is totally misconceived. Further, unaddressed in the N decision is the question of how Britain came to be so rich in resources and to have one of the most advanced healthcare systems in the world. There is no mention of the resource and labour extraction entailed in colonisation and the fact that Britain's economy and infrastructure are products of this history. Colonisation and ongoing forms of racial capitalist exploitation systematically destroyed vital means and methods of sustenance in Uganda and more widely in East Africa, severely affecting the health of local populations. Lord Hope characterises African countries as still suffering so much from the relentless scourge of HIV/AIDS. It is easy to put African countries' problems down to AIDS, which, as some scholars point out, is not a problem of Africa, but a problem of Western ethnocentrism. What Lord Hope does not say is that African countries are still suffering from the relentless scourge of colonialism. Another way of looking at N's case would have been to acknowledge that the resources in Britain that were keeping N alive, in fact, rightfully belonged to her. Although the absence of such a critical discourse in the courtroom is unsurprising, a decision like that of N must be understood as ongoing colonial violence. The judges acknowledged that N's presence in Britain was what was keeping her alive, but through the application of human rights law, they legitimised her removal, sending her to her death. N died within 3 months of her expulsion to Uganda. The judges construct wealth disparity and illness as unfortunate or natural occurrences, rather than products of a colonially structured world. Lord Brown thus characterises the suffering to be faced by N on removal as flowing from a naturally occurring illness. Lady Hale acknowledges that in Britain, HIV is a long-term but treatable illness, whereas in sub-Saharan Africa, for all but the tiny minority, she said, who can secure treatment, it is a death sentence. This is a jarring description, since the European Court of Human Rights decision in the case of Suring prohibits the return of individuals to countries where they face the death penalties. In the court's ruling in N, it was deemed that the alleged future harm would emanate not from the intentional acts or omissions of public authorities or non-state bodies, but instead from a naturally occurring illness and the lack of sufficient resources to deal with it in the receiving country. Yet the political cannot be bounded off in this way. The effect of constructing HIV and its lack of treatment in former colonies as a natural occurrence is to depoliticize the context of deep disparities in wealth and healthcare. The mass murder of colonized populations occurred not only through direct killings, but also as a result of resource deprivation, famine, and the spread of disease. Recurring famines in India, such as the Orissa famine in 1886, killed 1 in 3 people in the region. The response of the British government was to do nothing. Colonial authorities prevented individuals from providing relief and exported £200 million of rice to Britain. The colonial authorities argued that excessive deaths were nature's way of responding to overpopulation. Yet deaths as a result of famine were not a natural occurrence. They followed the East India Company's destruction of the Indian textile industry and forced people into agriculture, an industry dependent on the weather. Ultimately, the effect of the ruling in N is to reproduce the let die logic of colonialism, which saw colonial administrations construct the murderous spread of disease and famine as nature's way of dealing with so-called surplus populations. Thank you.
Hi,
so I think I'm
Nadine.
going to be, yeah, Chris, do you want to?
I was going to say a couple of questions have come in, so I've sent them on to you, so you should be able to see them if you want to raise them.
I'm just having a look. Okay, so what role does whiteness play in Boris Johnson's response to COVID-19? Thanks for that question. So yeah, I mean, you know, I've had about as much time as everybody else to think about that, and I think I definitely think, as I said at the start, that whiteness has played a big role in Britain's response to the virus, particularly Johnson's response. If we think about the temptation that Boris had to let the virus move through the population, and the arrogance with which the virus was treated from the outset, this assumption that this was happening somewhere else, to other people, to racialized people who were both, you know, constructed as having allowed the virus to spread in the first place through practices which are considered to be practices undertaken by races which are inferior to white races, and then the virus was constructed as being something that was happening in a place that bad things happen all the time, and that sort of thing can't happen here. That kind of assumption that white nations, white hegemonic nations, are free from the daily suffering that happens elsewhere, certainly I think guided the complacency and the arrogance with which this virus, this health crisis was being treated. And I think I think there's something quite specific about white British supremacy and white British colonialism. So it's not just whiteness in general, but I think white Britishness, because of course, as we know, Britain was essentially the winner in the era of competitive colonialism, and the kind of superiority and white supremacy, the very specific British brand, I think actually did open up Britain to suffering from this virus in the way that we've seen, because of the heightened levels of arrogance that we've seen on display. And of course, you know, we have a Etonian ruling class who no doubt seem to have been quite excited at the prospect of a eugenicist social experiment, which would test the strength of the British race genetically. You would really prove the British race to be able to survive this virus, and I think that's why we're seeing such a devastating an outcome for Britain, and of course, in particular, as I said, disproportionately racialized people. So I've got another question here asking, given how little justice the Windrush generation have seen, or the lack of justice for those in Grenfell, do you think that racialized victims of COVID and their families will see justice? Can the state ever be held to account? I think that's a really important question, because I do think it's important to think about what's happening right now in terms of justice and demands that need to be made in terms of justice. Absolutely, if we look at the total absence of state accountability on questions like Windrush and Grenfell, I can't say that I have much hope that there's going to be accountability for the victims and of the government in relation to families who have suffered needlessly because of decisions that have been taken over decades in this country by those in power, but also decisions taken in the more immediate term in the run-up to the sort of the outset of the virus and as it's developed. The question of whether the state can ever be held to account is a question I think about a lot in my work around deaths in custody in particular. I have been doing a study over the last couple of years of racialized death in custody victims and trying to think about state accountability. And I think that one of the things that I have really hung on to, and I have seen such an amazing display of in terms of the families fighting for justice for their loved ones when their loved ones have died in custody, is how they come together in moments of collective grief, how they display that grief, how they own that grief and their right to grief over people who are not humanized by the state, who are not seen worthy of being grieved by the state. And there's a real power in that. And I think that we've seen that with Grenfell as well, and the silent march. And so I think there are ways of holding the state to account, but we need to look for them in collective action and resistance where we can't find them in formal processes of accountability, whether that's in the form of public inquiries or court processes, because as we know, they often leave us totally unsatisfied in terms of accountability. So I've got another question. What is my response to the "You Clap for Me Now" viral video and other contemporary celebrations of Britain's immigrant communities? I mean, honestly, I mean, I feel it is too little too late. I mean, if we think about the way in which when the latest government was successful in coming to power in December, very shortly after, Priti Patel put out PR videos of herself announcing the new immigration policy, which would see, you know, the kinds of people we are relying on now to get us through this crisis, to take care of people in hospitals, in care homes, people derogatively referred to as unskilled. You know, she appeared with scientists in white coats. I mean, an absolute disaster in PR now in hindsight. She appeared by British scientists in white coats, essentially saying, how she was going to be making it much harder for the sorts of people we desperately need right now to come to this country. So, you know, essentially we're having a situation where healthcare workers are being required to put their lives and their families' lives on the line for people who only so recently voted them out of this country, both in the most recent general elections, but also in the course of the Brexit referendum, which of course I write about in the book. And I discuss at length what the referendum shows you know, how the referendum was totally dominated by immigration and racism in this country. So yeah, I think that the clapping for the NHS is something that I have been doing, and it is something that I've seen my neighbors doing, and that has given me the only thing I have taken from it is the fact that my neighbors, who some of them don't vote, have felt very neglected by the political establishment, have struggle in their everyday lives. We have come out together and we have seen each other and we have clapped, and for that reason alone I have felt a collective, it is the only sort of collective memorialization or anything that we can do in this time of social distancing. It's otherwise very difficult. But the kind of troopification we've seen of the NHS, this idea that they should be going into battle totally unequipped, the war mythology that is being pushed around this virus is totally inappropriate and very troubling for me. I'm going to move on because there are so many questions here. Okay, does the deeper point here not concern the colonial conditions of possibility of British state sovereignty in the first place? Any law then of bordering asylum otherwise is a symptom of racial sovereignty as law is merely an articulate of sovereign will? Yeah, absolutely. I mean, this is essentially what the book tries to capture. Is essentially looking at law as a tool of colonial violence, as being intrinsic to colonial violence. So yes, if you read the book, you will see that I agree with you. How would you describe the role of an immigration lawyer in the current immigration system? Does engaging in it at all make you complicit, provide legitimacy to the system, or do you think you can work against it from within? Yeah, so I do address this. Thank you for that question. I do address this in the book. I'm very clear that the work that immigration lawyers do on an everyday basis for individual cases are absolutely crucial. The arguments that lawyers will have been making in the end case, although they were unsuccessful, were extremely important in trying to save the life of that particular individual, but also of the countless cases, asylum cases, immigration cases. But of course, there is, as in all of our jobs, a complicity and a provision of legitimacy to all kinds of institutional violence. But that's not only the case of immigration systems. My work as a lecturer in a university makes me complicit in just the same kinds of institutional and border violence that we see played out in the immigration law system. If we think about how we are tasked with enforcing borders against our students, our tier 4 students, how universities are required to report students to the Home Office where they don't attend, and the registers that we keep as lecturers, reluctantly, but that we keep, are also complicit in this system. And so there's always a level of complicity. And I mean, what I'm trying to do with the book, I suppose, is to show how it is possible to see the work that immigration law does outside of its own system. Whilst I recognize it's important that immigration lawyers do the work that they do, I think that if we have the luxury as thinkers, as scholars, as students, as members of the public to think critically about the systems, about a system like the immigration law system, then we should do that. And so what I try to show is how law has a pedagogical role. It teaches white British people that they're entitled to everything within Britain, and what I'm trying to do is challenge that lesson through the book. So it's not an indictment of people who work within the system. It's actually, I think, and as what I've heard from a lot of immigration lawyers, who I'm so grateful to for engaging and reading the book, is actually that these are things that they think about working in the system, their own complicity, or how the system sort of locks them into this violence, and how they can see the violence of the system from within, and that they're actually relieved to see somebody talking about it in this way, because it's so difficult to talk about it when you're working within the system. can you perhaps say something about how you think Britain's perception of whiteness and race compared to that of other European countries? I mean, one thing that I come back to is when I think about the specificity of white British colonialism, is this quote, which I'm going to misquote now, from Cecil Rhodes, about the importance of extending colonialism because it means the expansion of the Anglo-Saxon race, and he calls it something like the best race in the world. So there was a specificity and a difference between different conceptions of whiteness across European countries. Britain certainly didn't see every white state as being the same in terms of its position on a hierarchy of race, a hierarchy of races. It considered the white British race to be the highest, and so I mean, I suppose that's what makes it important to me to think about specificities of different European colonial contexts, and that's what I try to do in the book, is to be sensitive to the specificity of white British colonialism. Okay, so here's a question. It's quite long, so just bear with me while I read through it. The central argument about need. I have a question about the central argument about the need for a justice approach based on colonial reparations. How would you see this applying in the context of migration from countries that had no colonial relationship to Britain? Can the same claim be made on a larger scale, i.e. colonized countries and colonizers in general, and or is there any need for additional, more universalistic framing of responsibilities? Thanks for that question. So one thing I do in the book is, although I talk about British colonialism and those with histories of British colonialism, I actually broaden this out to talk about some of the legacies of British colonialism that go beyond its specific legacies in relation to particular countries. So, for example, I think about legacies of racism more broadly, which actually pervade every corner of the world, regardless of whether that particular small corner minority in terms of the space that wasn't colonized by Britain. So I do think it's possible to broaden this out and think about the legacies of colonialism as we might broadly conceptualize them as race and racism, and how that can certainly push for a more broadly reparative argument, a more broad argument around reparations. Seeing if I answered the whole question. I think that will do for now. How does the assumption of the objectivity and rationality, reasonableness of judges and the law shape immigration law? Yeah, this is a really important question, and it's really one that's at the center of the book, in particular chapter 4, which I pulled out the section on the N case. Now, essentially what I'm trying to do is precisely challenge the notion that law somehow falls from the sky and is this neutral object that is purely designed to achieve justice in any particular outcome. And actually what I do is I look at the legal reasoning that is used by judges in a number of cases, and I look at how those cases are, and how that reasoning actually ends up driving forward colonial logics, and indeed legitimizing the immigration law system. And it's an immigration law system which I argue is colonialism ongoing, is an extension of colonialism. And I show that through looking at how, for example, the courts have interpreted a legal framework like that of the 1971 Immigration Act, which invented the concept of patriality, and thereby effectively limited the right to come to Britain to people who are white, people who are born in Britain or had a parent born in Britain, as I said, were 98% likely to be right at the time that the act was passed. And so what I do is I question whether we can ever really hope for justice from the courts when they are always working within the framework of law, the framework of immigration law, which in itself legitimizes the construction of Britain as a legitimately bordered nation state, which I am questioning in the book. I'm saying Britain is not a legitimately bordered nation state. If we look at the way in which Britain was made, how Britain was produced, if we look at Britain's colonial history, and how that contributed to the making of Britain today, and then if we look at how law was used, how immigration law was used intentionally to disenfranchise people of their rights, to actually bound Britain off, and therefore cut people off, cut people who had land, resources, wealth, health, opportunity, hope. But I characterize British spoils as being much broader than just what we might find in the British Museum, for instance. I look at all this and how immigration law has been used to bound access to colonial spoils, broadly conceived of. And then if we look at that, then we can really see immigration law as serving an entirely illegitimate purpose. Your work draws incredibly important links between how law works and the ways that racism and colonialism are perpetuated in current UK society. What suggestions would you have for the wider public in being critical of laws that are presented as otherwise neutral? Yeah, I mean, I try through the book precisely to reach a wider audience, and I'm not expecting, everybody who I'd want to read the book, but I have had some successes. A friend of mine who I've often had arguments with about this exact topic, and he thinks I bang on too much about colonialism and race, and I try to make it relevant to everything. He's read the book and he is convinced. We don't argue anymore. We have wonderful conversations with each other, which are very peaceful now, because he's read the book and he's completely convinced. So I hope people will read the book, because the book does try to precisely reach a wider audience and to ask people to question every day what they are taught, what they're taught by the law, what law teaches them. So yeah, short answer is read the book. Okay, thank you for sharing your work with us. You so effectively reveal the relationship between policy and law in the context of immigration. See similar in use of other laws such as collective punishment, joint enterprise. Yes. Where do we focus our push for accountability to bring the critical discourse into the courtroom through better informed legal practice, or challenge political discourse and policy narratives? I mean, yeah, this is a really hard question. I mean, of course, it's not unprecedented for judges to cite legal scholarship, but unfortunately, it's not this kind of legal scholarship which actually questions their legitimacy to give legal judgments, which is what particularly chapter 4 of the book does, but really the book as a whole. So I think it's unlikely that this kind of critical discourse can really enter the courts. But I think that the more practitioners who do engage with these kinds of arguments and can do the sort of work with which some organizations are already doing. So, for example, Akwaba, a really great migrant charity, invited me to give a talk on the book because they're really trying to embody in their practice a kind of politics that seeks to empower the people that they work with, the migrant communities that they work with. And that's really what the book is designed to do as well. What I'm saying to racialized people who are so often told, you don't have a right to be here, you should be grateful for being here, you should be lucky to access the resources that you do and to be in this country, it's precisely working against that discourse. And some of the most meaningful interactions I've had have been with young people, college students who I've gone and talked to about the book, who after hearing about the book kind of say, oh, I understand finally, where racism comes from, and I don't feel like people can tell me that I don't have a right to be here, because I do. And I think that kind of empowerment of people who legal practitioners work with is really important. And if legal practitioners can imbibe some of the book's message, and even though they're working within the system, make those who they're working with feel that although they need to go through this horrible experience, and an experience which is often demeaning, that they actually are entitled to be in this country, and to access resources, and that they should never be made to feel that they're somehow unjustly enriched. Do you have any thoughts on the post-Brexit immigration system? Will this lead to more immigration from the Commonwealth, and what implications might this have? I have reflected a bit on the post-Brexit immigration system. I mean, obviously, you know, we saw recently in the news that NHS workers whose visas are going to expire in October are going to have these automatically renewed. And I mean, some might look at this and say, oh, well, look, you know, this immigration system's changing, and you know, we're opening up more, and there's Boris Johnson thanking his migrant NHS staff. But frankly, I think that we have to be really wary of those kinds of outlooks. If we look at the change in the visa rules for this one group of workers, essentially what Priti Patel is saying is that we will extend the visas of people so that they can sacrifice their lives in order to save people who essentially voted these people out of the country so recently. The post-Brexit immigration system that we've seen put on the table essentially closes off all routes bar agricultural workers who are going to only be able to come seasonally. So there's going to be an end to any kind of permanent settlement, which is of course a very racist set of policies. The idea that we're trying to keep people from making Britain their home, keep racialised people in particular from making Britain their home, and to prevent poorer people from Eastern European countries from making Britain their home. This is a very this is the immigration system that's been put on the table, and we're seeing charter flights now being used to bring people because they're needed, because to pick crops, etc., in order to feed the nation this time of crisis. So it's a hugely cynical rowback that we've seen on some of these policies. I don't, as we and no, I don't think it won't lead essentially to more immigration from the Commonwealth. It's been made pretty clear in the announcements that were made post the election victory, the Conservative election victory, that there would be essentially an end to immigration of any kind that is not of the super rich.